Good morning, everybody. We take a report from Industry of Intellectual Property Competition, 13 October 2021. And today we will discuss about a case concerning YouTube versus Cyando. A very interesting, very new case of June 2021. And in case we're asking for the reference for preliminary rulings, intellectual property, copyright related right, and making available and management of the video sharing platform of file hosting and selling platform, liability for operator for infringement of intellectual property right by user of this platform. Condition for exemption from liability: no acknowledgement of specific infringement and notification of such infringement as condition for obtaining in injunction. So here the case. Frank Peterson versus Google LLC and Ashley versus Cyando. All right, so we have many elements here. We just go to judgment and a legal contest, and then the EU law, because that's the EU level, so of course they have many levels concerned to the European law from a legal perspective, and also for many things were going on for this case. So we can just go straight to the case at the point 18. Let's see the main part of the judgment. In order to understand more about the case, because the case is not really short as usual. The European case is always long, and otherwise make them very interesting to discover. And the case very interesting. So we have many questions concerned to the preliminary rulings, and we're going to see the first question, the second question, the fourth question, and we'll go to the conclusion. So here the case, we go back to the first question to see how the court will answer to case. So it's going to be very interesting point for the people. So just feel enjoy. So we go to the first case. Very first case. As a preliminary point, it should be noted that the question referred in the present cases concern copyright directive. The directive on electronic commerce and enforcement directive as applicable at the material time of the main proceeding. The interpretation provided by the court will answer to those questions do not concern the set of rules established by Article 17 of Directive 2019 of European Parliament of the Council of the 17th April 2019 on the copyright related right in the digital single market and amending Directive 96. We come to some questions below. The first question refers to the case C682, 19 and C683, 18. But the first question referred to each of those cases referring cause as innocence, where the Article 3 of the Copyright Directive must be interpreted and the meaning that operator of a video sharing platform or file hosting and sharing platform on which user can illegally make protected content available to the public. It shall make a communication to the public of the content within the meaning of that provision in conditions such as though at issue in the main proceeding. On Article 3 of the Copyright Directive, member states provide author with the exclusive right to authorize or prohibit any communication to the public of their work by wire or wireless means, including the making available to the public of the work in such a way that member of public may access them from place at a time individually chosen by them. Under that provision, author third have a right which is preventive in nature and which enable them to intervene between possible user of their work and the communication to the public, which such user might contemplate making in order to prohibit communication. Judgment of 9 March 2021, Bill Const, paragraph 21 of the case law cited. So as the courts have previously held, the concept of communication to the public within meaning of Article 3 of Copyright Directive should, as is underlined by recital 23 of that directive, be understood in a broad sense, covering all communication to the public, not present at the place where the communication originated, and thus any transmission or retransmission of a work to the public by wire wireless means, including postcarding. It is indeed clear from recital 4, 9, 10 of that directive that the principle of the objective that directive is to establish high level of protection of author, allowing them to attain the appropriate reward for use of their work, including when communication to the public takes place. Judgment 9 March 2021, VG Bill Kunst. At the time is followed by recital 3 and 31 of Copyright Directive, that the aim of harmonization effected by each to maintain, in particular in the electronic environment, a fair balance between, on one hand, the interest of copyright holder and related right in protecting the intellectual property rights safeguarded by Article 17.2 of the Charter of Fundamental Rights of Human of European Union, and on the other, the protection of the interest of fundamental right of user of protected subject matter, in particular the freedom of expression and information, safeguarded by Article 11 of Charter and of general interest. So we can see here in the European cases, they mention very often the definition, expression, and information. It's very, very important expression when you want to speak, and the ability to access information very, very important. It is clear that for the purpose of the interpretation and application of Copyright Directive, Article 3 thereof that a fair balance must be taken into account. So the particular importance of the interest to freedom of expression and of information. The course had held more than once the concept of communication to the public. So what this means? Within meaning 3 of the directive, including 2 cumulative criteria, namely of act of communication or work and the communication that work to the public, and require as individual assessment, judgment of 9 March 2021. For the purpose of such assessment, account had to be taken of several complement criteria, which are not autonomous and interdependent. Those criteria must, moreover, be applied both individual and in their interaction with each other, insofar as they may, in different particular situations, to present to a widely varying degree. Among those criteria, the court has first emphasized the indispensable role played by the platform operator and the deliberate nature of its intervention. The platform operator makes an act of communication when it intervenes in full knowledge of consequences of its action. To give its customer access to protected work, particularly where in absence of that intervention, the customer would not in principle be able to enjoy postcast work. Second, the court has testified that the consent of public refers to an indeterminate number of potential recipients and imply, moreover, a fairly large number of people. The court had also stated that, according to the settlement case law, in order to be categorized as a communication to the public, protected work must be communicated using specific technical means different from those previously used or failing that to the new public. That is to say to that the public were not already taken into account by the copyright holder when it's authorized the initial communication of its work to the public. In this instance, it should be noted that at the outset that potentially illegal content is uploaded to the platform concerned not by the operator but by user who act autonomously and who are responsible for those actions. In addition, this is a user platform who determine whether the content they have uploaded is available to all the internet users via the platform, so that those other internet users can obtain access to it at any time and from anywhere where they might individually choose. As regard uploaded file hosting and sharing platform, it is common ground that download link allow access to uploaded content is communicated only to the user who uploaded the file, and that the platform it's not possible to share that link and therefore the content uploaded with other internet users. Thus, in order to share that content, the user must either send the download link directly to the person to whom he or she wishes to give access to that content, or must publish that link on the internet, for example, in blog, forum, or link collection. As regards YouTube, video sharing platform, it appears that although the principal function of that platform consists in allowing its user to share videos publicly with all interest users, it also enables its user to upload content privately, and third to choose whether, as the case may be, with whom they wish to share that content. It's very, very controversial that case when people just upload the content privately. So how we can condemn them? Consequently, it must be held first that the user of the platform and issuing the main proceeding carry out an act of communication within the meaning of the case law refer to in paragraph 68 of the present judgment, where without the right holder consent, they give other interest user access via those platforms to protected work with those other internet users would not have been able to enjoy without the intervention of those users. Second, it is only if those users make the uploaded content available to the public within the meaning of case law referred to paragraph 69 of the present judgment. By sharing that content with any interest user on the YouTube platform, by publishing on the internet download link, give access to that content on the uploaded platform that the user and consequently the operator of platform use as the intermediary for making that content available and make a communication to the public within meaning of 3 of copyright directive. So the question became very, very complicated. By this first question, in each of 2 cases, the referring court seek to ascertain whether the operator of the video sharing platform or file hosting and sharing platform itself carry out an act of communication. In addition to that, and the case may be by the user of that platform. In that regard, should be noted that the operator of such platform plays a role that is indispensable where its user make potentially legal content available. If that platform were not provided and managed, it could be impossible or at the very least more complex freely to share the content on the internet. However, as is apparent from the case law cited in paragraph 67 and 68 of the present judgment, whether the role played by the operator of a video sharing platform or file hosting and sharing platform is indispensable is not the only criterion, which must be taken into account in the context of the individual assessment that must be made. It must, on the contrary, be applied in its interaction with other criteria, in particular the criterion relating to whether the intervention of such an operator is deliberate. If the mere fact that the user platform is necessary in order to the public to be available actually to enjoy the work, or the fact of that merely facilitated the enjoyment of that work, automatically result in the intervention of the platform operator being classified as an act of communication. Any provision of physical facility for enabling for making communication would constitute certain act, which is, however, that was recital 27 of the copyright directive, which reproduced in a sense. Accordingly, the importance of both roles that such intervention by platform operator play in the communication made by platform user and the deliberate nature of that intervention must guide the assessment of whether, given the specific context, that intervention must be classified as an act of communication. In that regard, it's clear from the case law cited in paragraph 68 of the present judgment that it is inter alia the act of intervening, the full knowledge of the consequences of doing so with the aim of giving the public access to protect work, which may lead that intervention to be classified as an act of communication. In accordance with that case law, the court had held that the making available and managing of the online sharing platform, the private bay, which by indexing metadata relating to protected work and providing a search engine allow users of that platform to locate their works and to share them in context of a peer-to-peer network, constituted the communication to the public. In that regard, the court stated inter alia that the Pirate Bay operator has intervened in full knowledge of the consequences of their product to provide a set of protected work that they had made explicit on blog and forum available on that platform. The purpose of making protected work available to users, and that they had encouraged the latter to make copy of those work. In order to determine whether the operator of video sharing platform or file hosting and sharing platform intervene in the illegal communication of protected content by user of each platform in full knowledge of the consequences of its conduct. In order to give all the interest user access to such content, it is necessary to take into account all the factors characterizing the situation at issue, which make it possible to draw directly or indirectly conclusion as to whether it's not intervention in illegal communication of that content were deliberate. In that regard, relevant factors include inter alia the circumstance that such an operator, despite the fact that it's known or out to know in a general sense that users of each platform are making protected content available to the public illegally via its platform. Refrain from putting in place the appropriate technological measure that can be expected from a reasonably diligent operator in this situation in order to counter credibility and effectively copyright infringement of that platform. And the circumstance that operator participated in selecting protected content illegal communicated to the public, that is provided to on platform specifically intended for the illegal sharing of such content of that, is knowing promote such sharing, which may be attested by the fact that operator has adopted by a financial model that encourage user of a platform illegally to communicate protected content to public via platform. On the other hand, the mere fact that the operator knows in a general sense that protected content is made available illegally on the platform is not sufficient ground to conclude that intervene with the purpose of giving interest user access to that content. The situation is, however, different, where that operator, despite having warned by the right holder that protected content is being communicated illegally to the public via this platform, refrain from expeditiously taking a measure necessary to make that content inaccessible. So moreover, although the profit-making nature of the intervention at issue is not irrelevant, the mere fact that the operator of video sharing platform or file hosting and sharing platform has the aim of making profit neither establish that is intervention in an illegal communication or protected content by some of the user of that platform was deliberate, nor give rise to an presumption that this is the case. In fact, that to provide information society services for profit does not mean in any way that the provider of such services consent to their being used by a third party to infringe copyright. In that regard, it is apparent inter alia from scheme of Article 8 of Copyright Directive, in particular Article 3, that it cannot be a presumption that mere provider of physical facility, which are intended to enable to make the communication and other intermediate services are used by the third party to infringe copyright themselves carry out acts of communication to the public, even though as a general rule they have the aim of making profit. A presumption to that effect cannot be interfered from a judgment, GS media. So we have many legal background refer to the first question, and that's super long. So just brief the case. In the light of all the foregoing, the answer to the first question refer in each of two cases is that Article 3 of the Copyright Directive must be interpreted as meaning that the operator of video sharing platform or file hosting or sharing platform on which user can illegally make protected content available to the public does not make a communication to the public of that content. Within the meaning of that provision, unless it contributes beyond merely making the platform available to give an access to such content to the public in breach of copyright. In that case, inter alia, where that operator has specific knowledge that protected content is available legally on its platform and refrain from expeditiously deleting it or blocking, etc. Or where that operator, despite the fact that is known or out to know in a general sense that user of a platform are making protected content available to the public illegally via its platform. Refrain from putting in place the appropriate technological measure that can be expected from a reasonably diligent operator in a situation in order to counter credibility and effectively copyright infringement on that platform, or whether that operator participated in selecting protected content illegally, communicated to the public, provide to on its platform specifically intended for the illegal sharing of such content, or knowing promote such sharing, which may be attested by the fact that operator has adopted a financial model that encourages user of the platform illegally to communicate protected content to the public via that platform. So you can see the idea of the European Court, they not really in favor of the acts of infringement. So we go in see what is the conclusion of European Parliament. So they said that the Directive 2001 must be interpreted at the meaning that the operator of video share platform or file hosting sharing platform on which user can illegally make protected content available to the public does not make the communication to the public of that content. All right. And always the case where the YouTube channel always winning. It's not really surprising. Within the meaning of that provision, unless it's contributed beyond merely making that platform available to give access to such content to the public in breach of copyright. In that case, inter alia, where that operator has specific knowledge that protect content available illegally on its platform and refrain from expeditiously deleting it or blocking, etc. Or where that operator is by the fact that it's know or out to know in general sense that user of a platform are making protected content available to the public illegally via a platform. Refrain from putting in place the appropriate technological measure that can be expected from a reasonably diligent operator in a situation in order to counter credibility and effective copyright infringement on that platform. or where that operator participates in selecting protected content illegally, communicate it to the public, provide tool on a platform specifically intended for the illegal sharing of such content or knowing promote of such sharing, which may be attested by the fact that operator has adopted a financial model that encourages user of a platform illegally to communicate protected content to the public via that platform. So the Directive 1000 must be interpreted as meaning that the activity of the operator of video sharing platform or file sharing platform fall within the scope of that provision, provided that operator does not play an active role of such kind as to give its knowledge or control over the content uploaded to the platform. So Directive 1000 must be interpreted as meaning that for such an operator to be excluded under that provision from the exemption from liability provided in Article 14, it must have knowledge of or awareness of specific illegal acts committed by its user related to protected content that were uploaded to its platform. Article 8 of Directive 1000 must be interpreted as not precluding a situation under national law whereby a copyright holder or the holder of related right may not obtain an injunction against an intermediary whose service has been used by a third party to infringe his or her right. That intermediary having had no knowledge or awareness of that infringement within the meaning of Article 14 unless before court proceeding comments that infringement had first been noted to that intermediary and the latter has failed to intervene expeditiously in order to remove the content in question or to block access to it and to ensure that such infringement do not recur. It is, however, for the national court to satisfy themselves when applying such a condition. That condition does not result in actual cessation of the infringement being delayed in such a way as to cause disproportionate damage to the right holder. So that's the case. We just spent an hour to discuss about the case, and very interesting to understand of some European law on the matter. Nguyen Cuong report from Institute of Intellectual Property and Competition, 13 October 2021. Thank you. See you again.